Hello everyone, I'm Praveena Gautam, advocate on record. I'm delighted to be associated with ILM as a faculty for the AOR course. I, uh, I have passed my graduation in science and then went on to do my law and having a vast experience of about 30 years now. As an AOR, I have a practice of over 25 years now. So today we are going to discuss about the AOR exam paper 1, which consists of practice and procedure. There are total 4 number of papers which are there for AOR exams. An AOR exam can be taken up by any advocate practicing at the bar for about 4 years, and 1 year in addition to 4 years before with any advocate on record as a trainee advocate. So after completion of 5 years of practice at the bar, that is 4 plus 1 year with the AOR training, they can take up this exam. So today we are discussing an overview of practice and procedure paper, which is paper 1. Practice and procedure is otherwise the core of the overall practice of the Supreme Court. To prepare for this paper, you must go through most importantly 2 books. One is Constitution of India and another is Supreme Court Rules 2013. So initially when the Supreme Court started working, the Constitution of India granted powers to the Supreme Court to frame its own rules for practice and procedure. That is how Supreme Court Rules 1966 came into being. Now, Supreme Court Rules 1966 were amended widely in 2013. So now the relevant Supreme Court rules now are 2013 Supreme Court rules. So to prepare for this exam, as I have already told you, you must go through Constitution of India and Supreme Court rules. We will categorize it into various aspects. The first aspect is the aspect of jurisdiction of the Supreme Court. So what kind of jurisdiction Supreme Court has, which it can try. So you can file various kind of petitions before the Supreme Court, like original petitions, appeals, review, references, original suits, which this jurisdiction flows from the Supreme Constitution of India itself. So in this lecture, we will be having overall view of paper 1. Now, Supreme Court widely has 7-8 jurisdictions. One is appellate jurisdiction, which is covered by Article 132 to 134A of the Constitution of India. It has extraordinary original jurisdiction under Article 32. It has inherent, or you can say plenary and discretionary jurisdiction under Article 142. It has also the original jurisdiction where original suit can be filed before the Supreme Court. We'll discuss it later. Then there is an advisory jurisdiction of the Supreme Court under Article 143, where government can send some issue for advice of the Supreme Court. Then there is extraordinary appellate jurisdiction, which is under Article 136, where SLPs are being filed, both criminal and civil. So let's discuss the constitutional status and role of the Supreme Court. The Supreme Court of India, as you know, is the highest judicial body outlined in Article 124 to 147 of the Constitution. It is not just the court of last resort, but a constitutional institution tasked with upholding the rule of law, maintaining federal balance, and safeguarding fundamental rights, judicial independence, which is a crucial for Supreme Court work. And it is protected by constitutional provisions such as security of tenure, fixed service conditions, and a strict impeachment processes. Article 141 confirms the Supreme Court judgments are binding, giving authority to the law declared by the Supreme Court. This elevates the litigation in the Supreme Court to a process that relies on doctrine of precedent. You can refer to the famous judgment of Supreme Court Advocate on Records Association versus Union of India, which was decided in 1993.